The Post-it note changed everything. I found it stuck to my coffee cup at 7 in the morning on the day that would determine whether we won or lost the biggest case of my career. The note was written in my partner's handwriting and contained a single word that I did not understand. The word was written in black ink and had been circled twice for emphasis. I stared at it while drinking my coffee and tried to figure out what message my partner was attempting to communicate to me. My partner had been acting strangely for weeks leading up to this trial. Sarah and I had worked together for 8 years, and I knew her habits and communication style well. She was always direct and professional in her approach to cases, but recently she had become secretive and evasive when discussing strategy for this particular lawsuit. I had attributed her behavior to stress from the high stakes involved, but now I wondered if something else was happening. The case involved a medical malpractice claim against one of the largest hospital systems in the state. Our client was a woman whose husband had died during what should have been routine surgery. The hospital claimed that complications were unforeseeable and that their staff had followed proper procedures. We had evidence suggesting that critical mistakes had been made and covered up. The potential settlement was worth millions of dollars. Sarah had been the lead attorney on the case from the beginning. She had conducted most of the depositions and developed our legal strategy. I had been assigned to assist with research and document review. This division of labor was typical for our firm, where senior partners took the lead on major cases. But I had noticed that Sarah was keeping me away from certain aspects of the case preparation, and I could not understand why. I walked to Sarah's office to ask about the Post-it note, but found her door locked and her lights off. Her secretary said she had called in sick and would not be coming to court that day. This news shocked me because Sarah had never missed a court date in all the years we had worked together. She was the type of person who would show up to work even with a high fever. Her absence on such an important day seemed completely out of character. The judge had made it clear that there would be no continuances or delays in the trial schedule. If Sarah could not appear, then I would have to step in as the lead attorney despite my limited familiarity with certain aspects of the case. I spent the next 2 hours reviewing files and trying to understand the full scope of our legal arguments. I discovered several documents that I had never seen before and realized that Sarah had been keeping information from me. One file contained communications between Sarah and representatives from the hospital's insurance company. The messages were dated from the previous month and discussed potential settlement negotiations. What disturbed me was that these conversations had taken place without my knowledge and apparently without input from our client. The insurance company seemed to be offering a settlement amount that was significantly lower than what we had been seeking. I called our client to inform her about Sarah's absence and to ask if she had been contacted about any settlement discussions. She said she had not heard from Sarah in over a week and was not aware of any negotiations taking place. She expressed concern about what was happening with her case and asked if there were problems with our legal strategy. I assured her that everything was under control, but privately I was becoming worried about Sarah's behavior. When I arrived at the courthouse, I was surprised to see Sarah's car in the parking lot. I assumed she had changed her mind about being sick and had decided to appear for the trial after all. But when I entered the courtroom, I saw only the opposing counsel at their table. The judge called the case to order and asked where the plaintiff's lead attorney was located. I stood up and explained that I would be representing our client due to my partner's illness. The defense attorney immediately objected to my appearing as lead counsel and requested that the judge postpone the trial until Sarah could appear. He argued that such a significant change in legal representation on the day of trial was unfair to his client and could result in an inadequate defense of their position. The judge seemed annoyed by the situation and asked me to explain why proper notice of the substitution had not been provided. I told the judge that Sarah's illness had developed suddenly and that we had not anticipated the need for a substitution until that morning. The judge was not satisfied with this explanation and warned that any delays or mistakes resulting from inadequate preparation would not be tolerated. He denied the defense motion for postponement, but cautioned me that I would be held to the same standards as an experienced trial attorney despite the circumstances. As I prepared for opening statements, I kept thinking about the mysterious Post-it note that Sarah had left on my coffee cup. The single word written on it was starting to make sense in the context of what I had discovered about her secret communications with the insurance company. I suspected that she was trying to send me a coded message about something important, related to the case. But I still did not understand what she wanted me to do with the information. My opening statement focused on the basic facts of medical negligence and the evidence we planned to present to prove our case. I outlined the timeline of events leading to our client's husband's death and explained how the hospital staff had failed to follow standard procedures. The defense attorney presented a strong counter-argument, claiming that the patient's death was due to unexpected complications rather than medical errors. Both presentations seemed to go well from a technical standpoint. During the lunch break, I drove to Sarah's house to check on her condition and to ask about the meaning of her note. Her car was not in the driveway, and no one answered when I knocked on the door. I used my key to enter the house since we had exchanged keys years ago for emergency situations. The house was empty, but I could see evidence that Sarah had packed bags and left in a hurry. There were clothes scattered on her bed and drawers left open. I searched through Sarah's home office for any additional files or documents related to our case. In her desk drawer, I found a folder containing copies of bank records and financial statements. The documents showed that Sarah had received several large deposits into her personal account over the past month. The deposits came from an account belonging to the same insurance company that represented the hospital we were suing. The amounts totaled nearly $200,000. The implications of what I had discovered were devastating. Sarah had apparently been taking money from the opposing side while pretending to represent our client's interests. This was not only unethical, but probably criminal. I realized that her strange behavior and secretiveness made sense if she had been working against our case from the inside. The Post-it note was probably her attempt to tip me off about what she had been doing without directly admitting her guilt. Returned to the courthouse in the afternoon with a completely different perspective on our case and Sarah's role in it. I began to suspect that she had been deliberately weakening our legal position to benefit the hospital's defense. This would explain why certain key documents seemed to be missing from our files and why some of our witnesses had become uncooperative. Sarah had been sabotaging our case while pretending to work in our client's best interests. The afternoon session involved testimony from our expert medical witness, who was supposed to explain how the hospital staff had deviated from standard care procedures. But as the witness testified, I noticed that his opinions seemed weaker and less definitive than what he had expressed during our preparation meetings. When I asked him specific questions about his conclusions, he gave answers that actually supported the hospital's defense rather than our claims. During a brief recess, I confronted our expert witness about his testimony and asked why his opinions had changed since our preparation sessions. He seemed uncomfortable and eventually admitted that Sarah had contacted him the previous week and suggested that he modify his testimony to be more balanced and less critical of the hospital. He said Sarah had told him that being too aggressive in his criticism might hurt our credibility with the jury. This revelation confirmed my suspicions that Sarah had been working against our case. I realized that I needed to act quickly to salvage the situation and protect our client's interests. But I also faced a serious ethical dilemma about how to handle my discovery of Sarah's apparent corruption. I could not accuse my own partner of taking bribes without solid proof, and I did not want to damage our case by creating additional controversy during the trial. I decided to focus on presenting the strongest possible case with the evidence I had available while avoiding any actions that might tip off the defense about what I had learned regarding Sarah's behavior. I recalled our remaining witnesses and asked different questions than what Sarah and I had originally planned. Instead of relying on the expert's modified testimony, I emphasized the documentary evidence that clearly showed problems with the hospital's procedures. If you were on the edge of your seat with that story of betrayal and courtroom drama, make sure to hit that like button, subscribe for more thrilling narratives, and turn on notifications so you don't miss the next case. Now, a question for you. What single word do you think was written on the Post-it note that Sarah left? Let me know your thoughts in the comments below. Until next time, always question the evidence.